Construction projects are complex. Disputes are common. Arbitration offers a private, efficient way to resolve these disputes. It is widely used in the construction industry. Arbitration is a process where parties present their case to a neutral third party, the arbitrator. This neutral party makes a binding decision. This process is faster and less formal than court. Arbitration offers several advantages over traditional litigation. It is confidential, allowing parties to protect their reputations. It is also flexible, allowing parties to tailor the process to their needs. Finally, arbitration can be more cost-effective than litigation, especially for complex disputes. Arbitration is crucial in construction contracts because it provides a clear path for resolving disagreements. This certainty helps projects run smoother and minimizes costly delays. When a dispute arises, parties must decide how to resolve it. Arbitration and litigation are two common methods. Each has pros and cons. Litigation involves going to court. It is a public process bound by strict rules of evidence and procedure. Pros include that precedents provide guidance and courts have the power to enforce judgments. Cons are that it can be slow and expensive and the public nature can damage reputations. Arbitration involves a neutral third party making a binding decision. It is private and more flexible. Pros include that it is faster and more cost-effective, it is confidential, protecting parties' reputations, and parties can choose an arbitrator with relevant expertise. Cons are that there are limited avenues for appeal and it can be more expensive than negotiation or mediation. Choosing the right method depends on the specific circumstances of the dispute. Factors to consider include the amount in controversy, the complexity of the issues, the relationship between the parties and the need for confidentiality. Understanding the arbitration process is crucial for successful resolution. Here's a general overview. 1. Initiation. One party sends a written demand for arbitration to the other party. This demand outlines the dispute and the desired remedy. 2. Appointment of arbitrator. Both parties agree on a neutral arbitrator or an appointing authority selects one. The arbitrator's expertise should align with the dispute. 3. Preliminary hearing. The arbitrator sets ground rules, schedules, and the scope of discovery. 4. Discovery. Parties exchange relevant documents and information. They may also take depositions from witnesses. 5. Hearing. Both sides present their case to the arbitrator. This includes presenting evidence and examining witnesses. 6. Award. After considering all evidence, the arbitrator issues a written decision called an award. This award is usually final and binding. 7. Enforcement. If a party fails to comply with the award, the other party can seek enforcement through the courts. Arbitration can be either domestic or international. The distinction impacts the applicable laws and conventions. Domestic arbitration occurs within a single country and is governed by its laws. International arbitration involves parties from different countries. It is more complex and often governed by international treaties like the New York Convention. Key differences include governing law. International arbitration often involves applying different national laws and international conventions. Enforcing international awards can be challenging due to varying legal systems. Cultural considerations. Parties from different cultures may have different approaches to dispute resolution. Parties should carefully consider these differences when deciding whether to include an arbitration clause in their contract.